Book. 469. I had read 468, my lord. I will start with 469. Citizens of a democracy cannot be compelled to have their lives pushed into.
Mr. Rodgi, just one second.
Just give us PDF page.
PDF.
My lord,
1048.
1048.
PDF will be 1048, my lord. Compilation page is 1017. And the reports page is 235.
Compilation is?
Which compilation is this? Volume?
Compilation 1.
Compilation 1, my lord.
Compilation 4.
Compilation 4, volume 1.
4 is all the judgments.
4 is foreign judgment.
Foreign judge.
4 is foreign
Foreign
judgment.
judgments.
So in that, volume 1 has
Volume 1.
volume, all the Putaswamy, etc.
I was reading from that yesterday, my lord.
No, we just lost track. 104.
Your lordships have.
469.
My lord, does Justice Call have it, my lord? Or?
Yeah.
Little improvement from
My lord, let me start with respect from 468, my lord. Contextually 468.
we got encouraged by your lordships for your efforts.
Mr. Dwivedi, I hope you are also working on your iPad.
I thought I'll
468.
see if it's persuaded me to do.
I'll try to persuade my lords, my colleagues.
The exercise of the natural and inalienable right to privacy entails allowing an individual the right to a self-determined sexual orientation. Thus, it is imperative to widen the scope of the right to privacy to incorporate a right to sexual privacy to protect the rights of sexual minorities. Emanating from the inalienable right to privacy, the right to sexual privacy must be granted, it's important now, the sanctity of a natural right and be protected under the Constitution as fundamental to liberty and as a soulmate of dignity. So my right now, my lord, is cast in stone by first the 9 judges and this. And if I may say so, my lord, in retrospect, I was thinking, in some measure, we are revisiting this issue, though this issue is decided. So, my lord, that's why I said, my lord, when we request a declaration from my lordships, the declaration should not only be a badge, that I wear a badge by saying that the Supreme Court has given me the right to say that I am married. But, my lord, it must at least go forward, even in some limited extent, not, my lord, the entire panoply of all the laws, but at least, my lord, in those laws which are otherwise secular, and which do not touch, my lord, personal laws, where that right has to flow and give me something real. I have made a list of 4 or 5 items, my lord, as an example. Take, my lord, Payment of Gratuity Act. Other acts which provide pension. They provide, my lord, only to a spouse where the underlying thing that you are married. I am going to give you, my lord, some of them. One of them, my lord, is the... hold on. I'll give you, my lord. One of them is judge's pension. A judge's pension will go to a spouse. Now, a spouse presupposes that you have to be married. So, if one of us, my lord, becomes a judge and then he gets a pension, tomorrow an issue will arise whether you are going, who will get the pension? My lord, for example, under the Income Tax Act, a gift is exempt from tax, my lord, as between members of a spouse which predetermines a marriage. Now, if you're going to do that, how will that work, my lord? So, there are a large number of acts. So, the secular acts, where, my lord, this issue doesn't arise of, my lord, personal laws. So the effect or declaration of marriage must flow to get us real rights, where, my lord, these day-to-day things, at least in secular parts, are, my lord, involved. Motor Vehicles Act. Gratuity Act, Pension Act, this is, Milord, Juvenile Justice Act provides for, Milord, adoption. Says you can't adopt. As a living, you can't adopt unless you are married. So all those, Milord, those at least, it must flow. Otherwise, what will happen? I'm sorry to use the phrase, I get a declaration, I get a badge. 5 years ago, I got that there will be no criminalization. After 5 years, I get this badge. Then, Milord, when I go somewhere, again those problems arise. They say, no, Supreme Court hasn't given you anything. Given you a badge of being married, fine. In society, you can go around and say, I am a couple who's married. But what is the real impact on the ground? Therefore, Milord, I have framed 1 or 2 reliefs, which I'll indicate. I'm only saying, Milord, idea should not be to go on revisiting the same issue from Puttu Swami and Navtej, back and forth. And we should only, at the end, if your lordships give me some, Milord, declarations, as and when in some other issues, something has to be fleshed out, it will come back to court. Nobody can, Milord, think of impossible.
Beginning of litigations.
Yes.
Mentally, as you call it.
Yes.
So rather than going at it whole hog.
Yes.
Whole hog you feel is a problem.
Yes.
Why is it a problem?
No. I am not saying it's a problem.
You don't want, because you don't want to open up the other fronts right now. You feel, what is the reason? You feel it's a distraction?
No, but I'm only saying only personal laws. I'm only saying.
The point is, there is an organic hole in this.
Yes.
That's one point is,
Yes.
get a declaration, then you say that in some of these, what you term as secular, or
I term them as secular, non-personal.
so far so good.
Yes.
But when it comes to personal law, this will also implicate personal law, isn't it? Because some of your
Some of them will argue, Milord.
Yes.
Menka wants to argue.
Therefore,
You don't want. All right.
you may not argue. You have strategic reasons why you will not argue. But this court will have to engage itself once more, twice more, maybe 3 times or 4 times more.
Yes, absolutely right.
Each one of these. The question is then we are not looking at it as a whole. We are looking at it in a truncated manner, which means that we, perforce, for the sake of, let's say, convenience or clarity, we say that we confine this declaration or whatever relief you are seeking to the Special Marriage Act, right? Which means that others who do not wish to or are not aware of this form of marriage, and I use these words very carefully, who are not aware of this form of marriage, of this going through the civil form of marriage, we can't presuppose, we can't assume that everyone knows this. They are denied this, right? Either they choose their religion or whatever. If they choose to, then they are out of this. So that is one aspect. Second aspect is the intersect with personal law even here. So keep that in mind when you make this.
Yes, madam.
Yes. I'll get to later. Yes. I appreciate, Milord, for your lordship's comment. So now 469. Citizens of a democracy cannot be compelled to have their lives pushed into obscurity by an oppressive colonial legislation in order to ensure the sexual and gender minorities' fulfillment of their fundamental right. It is imperative to confront the closet and, as the necessary consequence, confront compulsory heterosexuality. Confronting the closet will entail reclaiming markers of all desires, identities, and acts to be challenged. It also entail ensuring that individuals belonging to sexual minorities have the freedom to fully participate in public life, breaking the invisible barrier that heterosexuality imposes upon them. The choice of sexuality is at the core of privacy, but equally our constitutional jurisprudence must recognize that public assertion of identity found in sexual orientation is crucial to the exercise of freedom. But I submit 469 will fully apply, and instead of the words colonial legislation, we can use, Milord, the words colonial mindset. It is that mindset, Milord, which started from then. Society has evolved. Your lordships, Milord, struck down the barrier 5 years ago. But some parts of that mindset remain, which is evident from the stand of the respondents, including that of the states. And this mindset is, my lord, is implicit in the ground or at the ground level whenever we go to public spaces, and in the so-called, my lord, the secular laws which I am mentioning, which also will have to be read in accord with the declaration, if your lordship so grant the declaration. In other words, I will propose at the end, but I will just preface. My lord, wherever husband and wife is used, make it gender neutral by using spouse. Wherever, my lord, man and woman is used, make it gender specific, gender neutral by saying, my lord, person. And I will give your lordship examples in the Special Marriage Act itself. So kindly, my lord, note this. Husband and wife should be used as spouse, and man and woman should be used as person. A large part of this, my lord, will solve our projected interpretation, my lord, of the Special Marriage Act. And what is good here must also apply across, my lord, the spectrum, at least of the acts, my lord, the examples of which I'm talking about. So that's why I said, my lord, 469 will fully apply by removing legislation into a mindset which is evident even today. Then, my lord, the lordship turns 471. 471 talked about reputable and disreputable sex. Kindly see, my lord, the last line of that page. If one accepts the proposition that public places are heteronormative and the same-sex sexual acts partially closeted, relegating homosexual acts into the private sphere would in effect reiterate the ambient heterosexism of the public space. Which means, my lord, in other words, the rule of majority in public spaces. It must be acknowledged that members belonging to sexual minorities are often subjected to harassment in public spaces. The right to sexual privacy, founded on the right of autonomy of a free individual, must capture the right of persons of the community to navigate public places on their own terms, free from state interference. What I'm really requesting, my lord, for a declaration of marriage is really a paraphrasing of this. When I walk into a public space, I walk into the public space with my partner, knowing that the law and the state recognizes this union as a marriage. Nobody will raise a finger of stigma against me. I walk into this public space. I walk into, my lord, public employment. I walk into private employment. I walk in, my lord, for pensions, gratuities, etc. That I am equal to the heterosexual group. And it's not that the heterosexual groups, my lord, wishes or desires or their orientation is one which is correct, and all others, my lord, are incorrect, in the same phrase as reputable and disreputable in 471. So this started with, my lord, the negative part, that you won't do this. I am saying let there be a positive affirmation of the fact that since we are equal, created by judgments of this court from Puttoswamy downwards, from Nalsa downwards, if we are equal, my lord, require an affirmative, my lord, nod from the court that you are equal, marriage will be equal, walking into public spaces, public employment, private employment will be equal. There will be no stigma. You will not be treated as lesser mortals, as was being suggested yesterday by one of them. And therefore, there will be full enjoyment of the right to life, dignified privacy in my own house, in public spaces, in public employments. That is what, my lord, that is the adversity which we are facing today. I'm only trying to paraphrase the adversity which we are facing today. You go to a school, you write, my lord, parents' names, passports. All those things, my lord, create issues. All those things create issues. Because that's how, my lord, the concept has been. But concepts have evolved. We are not in the same position. I don't blame the 54 Act. When it was framed, that's how it was. But from 54 till today, we are 75 years down.
Okay, see what Brother Bhatt said. There will be moments, there will be incremental.
Yes, I agree.
They will take time. One fine day, everything cannot change. That must be kept in mind.
I know, but some amount
But
of real.
once, if you succeed and the status of a marriage is recognized, and if somebody doesn't follow that status of the marriage in another thing, then it's I would say it's a violation of the order of the Supreme Court, if we agree with you.
Yes,
If that is the position, then certain other changes will take some
I have no doubt.
step,
But
more time.
I entirely agree. But it should not be. I am at the absolute threshold. I am saying it should not be only, with that declaration that I go away. I should get some real benefit, don't call it benefit, some real filtering down of the effect of the order of this court.
If you succeed and it is held that under the Special Marriage Act,
Yeah.
this is a marriage which can be registered, that itself the registration is what you get.
I appreciate, but in several acts, what I'm trying to say is, it's like saying that consequential effect will follow.
It will,
Something like that, If I may show, I have tried to frame, give copies.
there may be,
I have tried to frame in my own words.
you are saying that the consequences of registration of the marriage
The other side.
in different scenarios will arise.
Yes.
Arise.
But just kindly see, I have tried to frame it, subject to your lordship's pleasure. If I succeed, then I may get something like this. Are entitled to marry under the Special Marriage Act, regardless of their gender identity and sexual orientation. This is the main declaration. The court may be pleased to direct that the marriage will be solemnized under the provisions of the Act. This is an adjunct of item 1. The words
So the first three.
yes. But I am more interested in 4. Have a look at 4.
I said 4 is a consequence of us.
Yeah, 1, 2, and 3 are really, paraphrasing the same thing. See 4. This I respectfully submit, subject to your lordship's pleasure. The court may be pleased to direct that all laws where rights, duties, obligations, and privileges flowing from marriage are conferred to a heterosexual couple married under the
Same thing. But you are saying that you want a specific
explicit
declaration. So
explicit,
according to you, the area of litigation should not be so wide that it creates a problem.
my lord.
And though you're confining it to the special marriage,
Yes.
you are saying whatever the consequences of registration
Yes.
must be available elsewhere.
I am very grateful. We spend a lot of time in very carefully drafting, within the contours. Because it should be explicit. Otherwise, every time, you start somewhere, you come up to the Supreme Court, 5-7 years go by. Our lives are in any case passing by, it becomes very difficult. I am not saying, that this struggle will end today. It can't end. But if we succeed, we should get an explicit declaration in terms of 4 or as modulated by your lordship, which flows from 1. Then,
Mr. Rohde, perhaps you may want to look at para 478 and 482.
Yes, I was going to. I also wanted to read 472.
470.
It's very important. Very important because of the heading. See, deconstructing the heteronormative framework. I am again and again, hitting this part because we are being buried under the pressure of the majority. Wherever we go, wherever we stand, wherever we apply, I am buried under that. Oh, look, this is abnormal. What is normal is what is majority. But that is not the law, That's a mindset. That is not the law, but that's a mindset. which is troubling us, my lord, in our daily lives. This is only an example to say public space, this, that. But that's what is troubling us, my lord. Therefore, my lord, the importance is deconstructing the heteronormative framework. This is what I am driving at. In the absence of a protected zone of privacy, individuals are forced to conform to societal stereotypes. Puttaswamy has characterized the right to privacy as a shield against forced homogeneity and as an essential attribute to achieve personhood. So I have that shield. That shield must be made explicit, that I will not, my lord, be traumatized or stigmatized only because I don't conform to the heteronormative majority. Then, my lord, after the quotation of Puttaswamy towards Placidum F, this court has recognized the right of an individual to break free from the demands of society and the need to foster a plural and an inclusive culture. The judgment of 4 judges in Puttaswamy said this. Kindly leave this, my lord. Kindly come to 474 for a few words. The right to privacy enables an individual to exercise his or her autonomy away from the glare of societal expectation. The realization of human personality is dependent on the autonomy of an individual. In a liberal democracy, the recognition of the individual as an autonomous person is an acknowledgement of the state's respect for the capacity of the individual to make independent choices. The right to privacy must be construed to signify that not only are certain acts no longer immoral, but there also exists an affirmative moral right to do them. I rely a lot on this part because the immoral part is now gone. So the negative and the positive. That's how we have our constitution also have affirmative, Milad, roles. Then, Milad, there's a quotation by Richards. Your Lordship may then turn 478, Milad, and 479. An individual's sexuality cannot be put in boxes or compartmentalized. It should rather be viewed as fluid, granting the individual the freedom to ascertain his or her own desire and proclivities. The self-determination of sexual orientation is the exercise of autonomy, accepting the role of human sexuality as an independent force in the development of personhood, acknowledgement of crucial role of sexual autonomy in the idea of free individual. Such an interpretive of autonomy has implications for widening applications of human rights to sexuality. Sexuality cannot be construed as something the state has the prerogative. This is important. Let me read this right again. Sexuality cannot be construed as something that the state has the prerogative to legitimize only in the form of rigid marital procreational sex. This is exactly, my lord, the argument of the other side. Biological man, biological woman, their union is marriage. Marriage will lead to procreation. That is the order of nature and nothing more. That is exactly the argument even today. That's why I say, my lord, in some ways we are revisiting it. Because apart from criminalization, I still face, my lord, these problems. Sexuality must be construed as a fundamental experience through which individuals define the meaning of their lives. Human sexuality cannot be defined narrowly in terms of function as a means to procreation. So, my lord, not the narrow or a pedantic view. To confine it to closed categories will result in denuding human liberty of its full content and a constitutional right. The Constitution protects the fluidities of sexual experience. It leaves to consenting adults to find fulfillment in the relations, diversity of culture, among plural ways of life, infinite shades of love and longing. By criminalizing consensual acts who wish to exercise their right, state is denying a citizen the right to intimacy. The right to intimacy emanates from the prerogative to engage in sexual rights, etc. Then, my lord, Shakti Vahini. That's important. My lord, I will not read Shakti Vahini because Shakti Vahini is quoted here. But my lord may note, my lord, on the side, there are 3 judgments. Shakti Vahini, Shafin Jahan, Lakshmi, and Deepika. I'll repeat, my lord. Shakti Vahini, Shafin Jahan, Lakshmi, and Deepika. These are 4 judgments which lay down and reiterate one principle, that every person is entitled to marry a person of his or her own choice. If it applies, my lord, to the heterosexual group or majority, I respectfully submit it will apply equally, my lord. To us, we may be a minuscule minority, but having the same rights are entitled to the same declaration granted, my lord, by this court in these 4 cases. Then, my lord, 480. In Shakti Vahini, a 3-judge bench of this court issued a directive to prevent honor killings at the behest of Khap Panchayat and protect persons who entered into marriage that did not have approval of Panchayat. So Panchayat can be Panchayat, community, whatever you call it, my lord. The court recognized the right to choose a life partner as a fundamental right. The learned Chief Justice held. When 2 adults consensually choose each other as life partners, it is a manifestation of their choice, which is recognized in Article 1921. Such a right has a sanction of constitutional law. Once it is recognized, the right needs to be protected, cannot succumb to the conception of class honor or group. Then, my lord, 481, Shafin Jahan. Shafin Jahan, this court set aside a Kerala High Court judgment which annulled the marriage of a 24-year-old woman with a man of her choice in a habeas corpus instituted by the father. The court upheld the right to choose a life partner. The Chief Justice held, expression of choice in accord with law is an acceptance of individual identity, curtailment of that expression and ultimate action emanating therefrom, or the conceptual structural of obeisance to society will destroy individualistic entity. The social values and morals have their space and are not above constitutionally guaranteed. One of us, Chandrachud J., recognize the right to choose a partner, the important facet. The choice of a partner, whether within or outside marriage, lies within the exclusive domain of individual. Intimacies of marriage lie within a core zone of privacy which is inviolable. I want to repeat this line. Intimacies of marriage lie within a core zone of privacy which is inviolable. The absolute right of the individual to lose a life partner is not in the least affected by matters of faith. Social approval for intimate personal decisions is not the basis. So majority is not the basis. It is my right. If it is the right, my lord, of the heterosexual group, I would respectfully submit it is jolly well, my lord, our right, because we are, my lord, equal human beings entitled to the benefits of the Constitution in the same manner as anybody else. Then, my lord, the judgment in Shafin Jahan delineated a space where an individual enjoys the autonomy of making intimate personal decisions. The strength of the Constitution, therefore, lies in the guarantee which it affords that each individual will have a protected entitlement, determining a partner, choice of partner, share intimacy, within or outside marriage. We are talking, my lord, of within today. Outside, my lord, in any case is available. In furtherance of the Rawlsian notion of self-respect, your lordship may see, my lord, last 4 lines of this para, just above platism G. This institutionalized expression to love must be considered as an important element in the full actualization of the ideal of self-respect. Social institutions must be arranged in such a manner that individuals have the freedom to enter into relations untrammeled by the binary of sex and gender and receive requisite institutional recognition to perfect their relations. Therefore, my lord, when I say I request for a declaration that we are married, we have to be married under this act, and the state will recognize and register. That, my lord, will be requisite institutional recognition, which will, my lord, follow from the court's declaration of the law under Article 141 and include, my lord, their acceptance, which will be followed by the acceptance of society. My lord, society accepts what the law is. Sometimes the law takes a lead. And I gave your lordship the example of Hindu widows' right to remarry act.
Day 2 of the arguments on the petitions on same-sex marriage taking place there in the Supreme Court. Let's go across to Sunil Prabhu now for more. And Sunil, today the centre tried to impede states also in this matter, and this was something that the Supreme Court refused. Just give us the details. The centre has reached out to states to get their opinions on this matter as well.
That's right. You're absolutely right. The Health Secretary has finally written a letter to the states saying that, because of the fact that the Supreme Court is hearing this matter, and even though they are not made party, in case the center has to put its viewpoint across, so they would like to do it. Gargi, we must put things in perspective. It is not that, suddenly things have suddenly come up. This was a matter which was being pressed by the petitioners for some time, and everybody was well aware that a constitutional bench had been, agreed upon, even though the center had questioned its maintainability. All those issues were being looked at by the Chief Justice of India, and that is why, in his normal self, he said, good, we have noted, and really allowing the constitutional bench to continue with the resumption of the arguments that are taking place, giving time for the center to continue with that entire process. So, having taken note of the center's objections, the center, as you're well aware, didn't want, firstly, the Supreme Court to hear this matter. Secondly, it said states must be implemented. And thirdly, it went on to say that there is a huge lacuna in terms of, opening up this entire issue. Having said that, the Chief Justice of India and his bench have decided to hear this matter. They continue to hear, as you see, live proceedings of no less than the former Attorney General of India, Mukul Rohatgi, speaking on behalf of its petitioners. It is now day 2. He has been speaking now for the last 3 hours, trying to make an effective case of why the Supreme Court needs to amend and read down the Special Marriages Act and not confine it to just man or woman, and make it to persons or a spouse, so as to allow people with who have certain, be it homosexuals or lesbians, the queer community, access to the institution of marriage and the rights thereon. Just to give you a small brief, Justice Krishna Kaul, who said even if you succeed, this can be done only on an incremental basis. It can't be done in a full basis. And we must understand that once Section 377 was decriminalized, now this is the second step. And in this step, if the Supreme Court does respect and accept the concept of marriage between two persons and not man and woman, then definitely there will be a flow in terms of other inheritances, adoption, and various other rights which will flow from this. So in this backdrop, the Supreme Court continues to hear this matter. This is a constitutional bench. This is a matter which will affect a number of citizens, even though they are a minuscule minority today, but it will be recognizing their right to privacy and their fundamental right to live.